Imagine realizing that if you wanted to protect your privacy, your family, and even basic facts about your life, you would have to take some of the most powerful media companies in the world to court. For Meghan Markle and Prince Harry, that is not a thought experiment. It is the path they chose. Over just a few years, the couple have launched a series of high-profile legal cases against newspapers and photo agencies in Britain and North America. Some they have already won. Some are still moving slowly through the courts. Together, they tell a story about what happens when people who are usually written about decide to push back at the people doing the writing. Today on Royally Misrepresented, we are going to walk calmly through that story. A clear timeline of the major lawsuits involving Meghan and the press, what each one was really about, what the courts decided, and which battles are not over yet. Welcome to Royally Misrepresented, your calm space for context and facts in a very noisy royal conversation. If you are tired of outrage, but you still want to understand what is actually happening around Meghan Markle, the Sussexes, and the media, you are in the right place. In this video, we are going to focus on three kinds of legal action. First, the cases Meghan herself brought, especially her landmark privacy and copyright claim over the letter to her father and the paparazzi cases involving photos of her son. Second, the related claims Harry has brought against the same publishers, because they are part of the same wider strategy against specific newspapers. Third, the big ongoing case against the publisher of the Daily Mail over alleged unlawful information gathering, which could still reshape parts of British media if it succeeds. By the end, you will have a clear map of what happened when, and you can decide for yourself what this legal campaign really says about Meghan, about the press, and about power. It is easy to see these cases as celebrity dramas, but behind the headlines, the stakes are serious. On one side, there is the principle of free press, able to investigate powerful people. On the other hand, there is the right to private life, to personal data, and to safety in your own home and with your own children. When Meghan sues a newspaper for printing a private letter, or when the couple sue a photo agency for flying drones over their garden, they are not only arguing about one article or one picture. They are asking courts to draw a line in a digital age where information can be copied and spread in seconds. They are also taking huge financial and emotional risks. These cases cost millions in legal fees on both sides. Judges have warned Harry and the other claimants in the current Daily Mail case that if they lose, they could be responsible for very large parts of the publisher's costs. So this is not just about reputation. It is about money, precedents, and the future rules of the media environment we all live in. Part 1. The letter that became a test case. Our timeline starts in early 2019. In February that year, the Mail on Sunday and Mail Online published articles quoting large sections of a long handwritten letter Meghan had sent to her father, Thomas Markle, after her wedding. The letter was deeply personal. It talked about their damaged relationship and her feelings around his dealings with the press. In October 2019, Meghan brought a claim in the High Court in London against the paper's publisher, Associated Newspapers. She argued that printing the letter was a misuse of her private information, a breach of her copyright, and a breach of data protection law. Associated Newspapers argued that publication was legitimate. They said Thomas Markle had the right to share his side of the story, and that there was a public interest in correcting what they saw as a misleading picture created by an earlier People magazine article which had described the letter without printing it. Rather than waiting for a full trial, Meghan's team asked the judge for summary judgment on key parts of the claim. That means asking the court to rule that the publisher's defense has no realistic chance of success based on the legal principles and the facts that are not in dispute. In February 2021, the judge agreed. He ruled that Meghan had a reasonable expectation of privacy in the contents of the letter, and that publishing those contents in the way the Mail had done was manifestly excessive and unlawful. He said there was no prospect that a trial would lead to a different conclusion on that issue. He also found that Meghan owned the copyright in the text and that using it without permission was an infringement. Some smaller issues, including exactly how much friends had contributed to the wording, were left for later. Associated Newspapers appealed, but in December 2021, the Court of Appeal upheld the ruling. The judges said the decision was correct and that the paper had indeed breached her privacy and copyright. In statements after the judgment, Meghan described it as a victory not just for herself, but for anyone who has ever felt scared to stand up to a media outlet. The publisher said they were disappointed and considered it a restriction on their ability to report. From a legal point of view, this case is important. It confirmed that even very famous people can have private written communications protected, and that newspapers cannot simply rely on public interest to justify publishing large amounts of intimate material. It is also the clearest example of Meghan herself taking a paper all the way to court and winning. Part 2. Fighting the cameras. At the same time as the letter case, Meghan and Harry were dealing with a different kind of intrusion. After stepping back from royal duties and moving first to Canada, then to California, they found that interest from photographers did not disappear. If anything, it intensified. In July 2020, they filed a complaint in a court in Los Angeles against unnamed paparazzi agencies. They alleged that their young son, Archie, had been photographed in the garden of their home using drones, helicopters, and long lenses, and that the images were being marketed to outlets around the world with false claims that they were taken in a public place. Later that year, they announced a settlement with the agency X17. The company apologized, agreed to hand over the original images and to destroy any copies, and promised not to take or sell similar photographs in the future. In a separate case, Meghan brought legal action in Britain against Splash UK over long lens pictures taken of her walking with Archie in a park on Vancouver Island. In that settlement, Splash accepted that the photos were taken in breach of privacy rights. The company agreed not to take further photographs of the family and its United Kingdom arm, later went into liquidation. These cases did not create the same headlines as the letter ruling, but they mattered in another way. They signaled that the couple were prepared to use privacy and data protection law not only against newspapers, but also against the agencies that feed them images. Together, the letter case and the paparazzi settlements show the first phase of their legal strategy. Draw a firm line around the home and around certain kinds of private communication and force media companies to pay a price when they cross it. Part 3. Libel and the fight over reputation. While Meghan was leading on privacy and images, Harry began to bring his own actions, many of them in libel and phone hacking. In 2020, he sued Associated Newspapers over articles in the Mail on Sunday and Mail Online that claimed he had turned his back on the Royal Marines after stepping down from royal duties. The stories suggested he had failed to keep in contact with the forces and had snubbed them. In February 2021, the case settled. The publisher accepted that the article was false, apologized in open court, and agreed to pay damages, which Harry donated to the Invictus Games Foundation. Around the same time, Harry and Meghan also challenged a report by the BBC, which suggested the late Queen had not been consulted about their choice of the name Lilibet for their daughter. Lawyers for the couple wrote to the broadcaster and other media describing the claim as false and defamatory. This exchange stayed at the level of legal warning rather than becoming a full lawsuit, but it shows again how willing they were to act when they felt reporting crossed a line. These libel and pre-litigation moments are part of the same pattern. They are not only asking for privacy in the strict sense, but for accuracy when newspapers describe their actions and motives. Part 4. Phone hacking and historic unlawful information gathering. The most complex and long-running legal battles are the ones Harry has pursued over historic phone hacking and unlawful information gathering. He has brought claims against Mirror Group newspapers, News Group newspapers, which publishes The Sun, and Associated Newspapers, which publishes the Daily Mail and Mail on Sunday. The allegations cover a wide range of behavior, from voicemail interceptions to the use of private investigators to obtain private data. In December 2023, after a trial against Mirror Group, a judge found that there had been widespread and habitual unlawful information gathering at its titles for many years. He ruled that Harry's phone had been hacked to a modest extent and that some stories about him were the product of unlawful methods. The court awarded him £140,600 in damages. In February 2024, the rest of his claim against Mirror Group was settled, with further payments towards his legal costs. In January 2025, News Group newspapers, the publisher of The Sun, agreed to settle Harry's privacy case before trial. In a statement read in court, the company offered a full and unequivocal apology for serious intrusion into his private life in earlier years and confirmed that it would pay substantial damages. Harry described the settlement as a step in a much longer campaign to expose what he calls systemic wrongdoing in parts of the press. The last and most controversial of these historic cases involves Associated Newspapers. Harry is one of 7 claimants, alongside figures such as Elton John, Baroness Doreen Lawrence, and Elizabeth Hurley, alleging that the publisher engaged in unlawful information gathering over many years. The methods alleged include phone interception, bugging of private spaces, and obtaining confidential records. Associated denies the claims and says they are based on inference rather than evidence. In 2023, the High Court allowed the case to proceed, rejecting Associated's attempt to have it thrown out at an early stage. In late 2024, the court directed that a trial should take place in early 2026. Recent hearings have focused on the very high legal costs on both sides and on disputes about the reliability of some witness statements. Meghan is not a named claimant in this particular action. But in public statements and interviews, Harry has been clear that his fight with these publishers is also about how they have treated his wife and family and about attempting to change the wider industry. Part 5. What this timeline actually shows. When you lay all of these cases side by side, a pattern emerges. Meghan's main direct actions have been tightly focused: a privacy and copyright case over a deeply personal letter, targeted claims against agencies that photographed her child in settings she believed should have been private. Harry's actions have been broader, attacking both recent coverage and historic behavior through libel, hacking, and unlawful information gathering claims. Together, they form what one legal commentator called an unprecedented cluster of cases by a member of the royal family against the press. You can look at this in more than one way. Some see it as a necessary correction, using the law to push back on decades of harassment and on practices that have now been found illegal in court. Others see it as an aggressive campaign that risks chilling investigative journalism and shifting power too far towards wealthy individuals who can afford long legal battles. What is clear is that this is not random. It is a deliberate choice to treat the courts as the main tool for drawing boundaries with certain outlets, rather than relying on quiet negotiations or public complaints alone. So what do you take from this timeline? Do you see a couple misusing the courts to punish criticism? Or do you see 2 people who decided that after years of intrusion and distortion, the only realistic way to set limits was through judges and legal rulings? How do you balance the value of a free press with the need for real privacy and safety, especially for children? Let me know your thoughts in the comments, and please keep them thoughtful and respectful. This channel is for people who want more than team sport around Meghan and Harry. It is for people who want to understand how power, media, and law really interact. If this deep dive helped you see the bigger picture more clearly, you can support Royally Misrepresented by liking this video, subscribing, and sharing it with someone who has only seen the headlines, not the timeline. From a private handwritten letter to large-scale claims about unlawful information gathering, Meghan Markle and Prince Harry have done something unusual. They have moved from being subjects of coverage to being central players in the legal story about the press itself. Some of their cases are finished with clear wins on privacy and reputation. Others are still moving slowly towards trial, with no guaranteed outcome. But taken together, they have already forced courts to revisit the balance between public curiosity and personal rights. Thank you for spending this time here, for your attention, and for being willing to look at the details rather than just the drama. Take care of yourself and the people you love, and I will see you in the next video.